I would like to close with a series of selections from existing case law that may not be evident to people. So what the actors are going to do, they're going to step forward once again, and they're going to read a series of short paragraphs from some Supreme Court cases. And the first one we have is from Justice Field in the Chinese Exclusion Case of 1889.
The differences of race added greatly to the difficulties of the situation. Notwithstanding the favorable provisions of the new articles of the Treaty of 1868, by which all the privileges, immunities, and exemptions were extended to subjects of China in the United States, which were accorded to citizens or subjects of the most favored nation, they remained strangers in the land, residing apart by themselves and adhering to the customs and usages of their own country. It seemed impossible for them to assimilate with our people or to make any change in their habits or modes of living. As they grew in numbers each year, the people of the coast saw, or believed they saw, in the facility of imagination and in the crowded millions of China, where population presses upon the means of subsistence, great danger that at no distant day that portion of our country would be overrun by them unless prompt action was taken to restrict their immigration. The people there accordingly petitioned earnestly for protective legislation. To preserve its independence and to give security against foreign aggression and encroachment is the highest duty of every nation. And to attain these ends, nearly all other considerations are to be subordinated. It matters not in what form such aggression or encroachment come, whether from the foreign nation acting in its national character or from vast hordes of its people crowding in upon us. The government, possessing the powers which are to be exercised for protection and security, is clothed with the authority to determine the occasion on which the powers shall be called forth, and its determinations, so far as the subjects affected are concerned, are necessarily conclusive upon all its departments and officers. If, therefore, the government of the United States, through its legislative department, considers the presence of foreigners of a different race in this country who will not assimilate with us to be dangerous to its peace and security, their exclusion is not to be stayed because at the time there are no actual hostilities with the nation of which the foreigners are subjects.
Next selection is Justice Harlan in Plessy versus Ferguson, 1896.
There is a race so different from our own that we do not permit those belonging to it to become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race. The white race deems itself to be the dominant race in this country, and so it is, in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty.
Justice Black in the Japanese Internment Case, 1944.
It is said that we are dealing here with a case of imprisonment of a citizen in a concentration camp solely because of his ancestry without evidence or inquiry concerning his loyalty and good position towards the United States. Our task would be simple, our duty clear, were this a case involving the imprisonment of a loyal citizen in a concentration camp because of racial prejudice. Regardless of the true nature of the assembly and relocation centers, and we deem it unjustifiable to call them concentration camps with all the ugly connotation that term implies, we are dealing specifically with nothing but an exclusion order. To cast this case into outlines of racial prejudice without reference to the real military dangers which were presented merely confuses the issue. Korematsu was not excluded from the military area because of a hostility to him or his race. He was excluded because we are at war with the Japanese Empire, because the properly constituted military authorities feared an invasion of our west coast and felt constrained to take proper security measures, because they decided that the military urgency of the situation demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily, and finally, because Congress, reposing its confidence in this time of war and our military leaders, as inevitably it must, determined that they should have the power to do just this. There was evidence of disloyalty on the part of some. The military authorities considered that the need for action was great and time was short. We cannot, by availing ourselves of the calm perspective of hindsight, now say that at time these actions were unjustified.
Justice Powell in United States versus Brignoni-Ponce in 1975.
Even if they saw enough to think that the occupants were of Mexican descent, this factor alone would justify neither a reasonable belief that they were aliens, nor a reasonable belief that the car concealed other aliens who were illegally in the country. Large numbers of native-born and naturalized citizens have the physical characteristics identified with Mexican ancestry, and even in the border area, a relatively small proportion of them are aliens. The likelihood that any given person of Mexican ancestry is an alien is high enough to make Mexican appearance a relevant factor, but standing alone, it does not justify stopping all Mexican Americans to ask if they are aliens.
And finally, Justice Brennan in United States versus Martinez-Fuerte in 1976.
Every American citizen of Mexican ancestry and every American citizen of Mexican ancestry and every Mexican alien lawfully in this country must know after today's decision that he travels the fixed checkpoint highways at the risk of being subjected not only to a stop, but also to detention and interrogation, both prolonged and, to an extent, far more than for non-Mexican appearing motorists. To be singled out for referral and to be detained and interrogated must be upsetting to any motorist. One wonders what actual experience supports my brethren's conclusions that referrals, quote, should not be frightening or offensive because of their public and relatively routine nature, unquote. In point of fact, referrals, viewed in context, are not relatively routine. Thousands are otherwise permitted to pass. But for the arbitrarily selected motorists who must suffer the delay and humiliation of detention and interrogation, the experience can obviously be upsetting. And that experience is particularly vexing for the motorist of Mexican ancestry who is selectively referred knowing that the officer's target is the Mexican alien. That deep resentment will be stirred by a sense of unfair discrimination is not difficult to foresee.
Ladies and gentlemen, thank you very much for your patience.